attend any appeal. So, at this time, I'd like to move a motion to go into executive session pursuant to 1 MRS 5046E to discuss with legal counsel the interpretation appeal of Mr. Adan Eldorado. Is there a motion?
I'll motion.
Is there a second?
Second.
All in favor to go into executive session? Okay. Okay, we're on the air. Like a motion to come out of executive session.
I'd like to make a motion to come out of executive session.
Second. All in favor of coming out of executive session? Motion carries. Okay, just want to quickly, there were no decisions obviously made in executive session. We don't have the right to do that. We're going to come out of executive session. We're just there to get a little bit more background on this case, because it is a bit confusing, and we want to make sure we did this correct. Okay, now, there's three things that we have to determine so that we can hear this case. And of course, I've managed to lose my paper. All my notes.
I'm more than happy, Mr. Chairman, if it's helpful to frame those up.
Yeah, I would like, I don't know how to put that. Okay, let's, I'm going to let the lawyer, I'm sorry, I forget.
Leah Racham, Attorney Racham, yes.
Yes, our attorney, frame up the three questions that we discussed, or the three issues.
Sure. Okay, so I think the standard protocol here is that you open the public hearing, you hear from the applicant first, then you hear from the code office, members of the public who may wish to weigh in, and then the applicant has the opportunity to respond to anything that's been raised, right? And like every appeal that comes, or any application that comes before you, there's the substance of the matter, but then there are these threshold issues that you have to, or the applicant has to satisfy before you can jump into the substance. And those basically are germane to this board's jurisdiction to hear hear what is coming before you. And so there are three things. The first is jurisdiction, meaning whether this board has the authority to hear what they are being asked to do. And that's simply because all municipal boards, this board, municipal officials only have, we say they're creatures of statute and ordinance, and they only have that authority which they've been specifically granted. So you've got to establish that you have the authority to hear the application. The second hoop that applicants must all jump through is this notion of standing, meaning they have right, title, and interest in the property that's at issue. And without that, this board can't make a determination. You know, I give the silly example, but if I, Mr. Chairman, wanted to apply for a building permit on your property, clearly I can't do that because I don't have sufficient right, title, and interest to ask for that. And the third thing is timeliness, right? Your ordinance prescribes, I believe it's a 30-day window in order for the application to be timely, that the decision being either here in an administrative appeal, the decision being appealed from, or if it's an interpretation, it has to be 30 days from that interpretation. So those are those threshold issues that I think need to be determined before you can get into the merits of the case. And so just for expediency and practical purposes, it may make sense to have the applicant speak to those jurisdictional issues first, hear from the code officer if they are inclined to make any submissions in that regard, make your threshold determinations, and if you find jurisdiction, then of course you get into the merits. But that's how I would conceive of it. Perhaps you might want to hear from the parties if that's a process which they are amenable to, if they agree to it. I think.
I think I'm going to supersede the asking if they're amenable, because I want to go through them one at a time, and at that point in time, the parties will have an opportunity to speak, if it's necessary, on each one. Yes, Board of Appeals?
No, meeting with the...
Jeremy, everybody's in the auditorium, honey.
Upstairs. So sorry.
Sorry. We might get a lot of that, Mr. Chair, sorry.
We're going to go through these one at a time. That's my intention. And the board will vote on each one so that we have a clear understanding of, as we proceed, if we have jurisdiction to actually hear this appeal. So the first one is on interpretation of the jurisdiction. I'm going to let the lawyer speak to the interpretation?
Sure. So, you know, when we look at this board's jurisdiction, you are allowed to enter, your powers and duties are with respect to variances. That's not this. Administrative appeals, meaning if there's a concern around or a disagreement with a decision of the code enforcement officer, then the appealing party can ask this board to decide whether or not that decision was supported or it was correct or not. And then the third is an interpretation of this ordinance. And I say, I'm using air quotes because we're talking about the land use ordinance, this ordinance. So those are your three, basically what your authority is. Those are the things that you can hear. And so you have to determine with respect to this application you have before you, what it actually is. There may be some confusion as to whether it's an administrative appeal or an interpretation. You hear from the applicant in that regard. You make a determination if you have authority to hear it. And then with respect to interpretation, you know, I look at the application and it says, it actually talks about an interpretation of what it appears to be a state statute, and whether or not that's an interpretation of this ordinance is something you might want to hear from the parties about.
Okay. So, going to our ordinance, to me, it's pretty clear on the 10.3C that we have the authority to make interpretations to the ordinance. And I believe the applicant is asked for an interpretation to the ordinance. So I don't feel like I need any input from anyone on that. It seems pretty clear to me. Does anyone else on the board feel like we need any more information on our jurisdiction on 10.3C, which says we have the right to hear an interpretation?
I think it does make sense to ask the applicant if that is in fact what he's asking for, yeah.
I believe I saw you nodding your head, so
Yes, that is
I didn't ask.
application, yeah.
Yep.
No disagreement.
Okay. So I'm going to go through this one at a time. I just feel like it'll be much cleaner that way. So I'm going to look for a motion that we have jurisdiction for interpreting this application.
And just before you do that, Mr. Chairman, I think what's important is, yes, you have jurisdiction over interpretation. I think one of the issues is whether what is asked for, the interpretation was asked for of a subdivision law, a state statute, and whether or not that is akin to this ordinance.
Well, I think we'll take that as the second step, if that's okay.
Sure.
I just thought do I have a motion to agree that we have jurisdiction in the ordinance by 10.3C to hear this appeal?
I'd like to make a motion to see that the board agrees that we have a jurisdiction to make an interpretation of part of the law.
You have a motion? Second?
Second.
All in favor? Okay. The next piece of this, I know this is long and drawn out, but I just wanted to make sure I'm comfortable where we're headed with this. The application is for state statute. And so that concerned me when I first saw the application, because I didn't feel like I didn't know if we had the right to interpret state statute. So I'm going to let our lawyer again speak to that issue, and then if there's any concerns on either party, we'll let them speak.
Okay, thank you, Mr. Chairman. So I share that concern in the sense that it's very clear when we were talking about before that this board's authority is the interpretation of this ordinance. Now, in the application itself, it asks for an interpretation of state subdivision law, which ordinarily I would say, you know what, I think that's beyond your purview to interpret state law. However, if you look back to this ordinance, being the land use ordinance, if you look at the definition of subdivision in your own ordinance, it just basically cites out to the exact provision that Mr. Eldraji has cited. And so while ordinarily I would say this board does not have the right to interpret state statute, because it was adopted, I would and of course we want to hear from the parties on that, but because it was adopted by the town meeting as part of your land use ordinance, then I think you could find that you do have authority to consider that, or interpret it, so to
Okay.
speak. Yeah. But you may want to hear from the parties on that.
I will ask either party, Mr. Alderogi, I'm assuming you provided us the...
Can you please stand at the microphone? Thank you.
Me and Terry looked it up, and it did state exactly what she had mentioned. It refers you back to the statute in the ordinance book.
Okay, thank you.
Yeah, I think that's a reasonable interpretation too, and I just want to point out in your last decision on this, you actually made a finding on that, and it's sort of similar, kind of a somewhat similar situation where it was a little bit arguable, it's a little gray, but you decided you did have jurisdiction to decide the issue. It was a little different context because of the building permit, but you did go ahead and decide a subdivision last time, so I think that would be consistent with what you've done.
Does the board have any questions for anyone on this? Or do you feel like we're ready to make a motion to, that we do have statute to interpret main statute, have authority to interpret main statute? Is that are we okay on that? Right, do we have a motion on the table?
I'll motion.
Okay, Mr. Beach makes a motion. Is there a second? Mr. Wood, seconds. All in favor that we do have jurisdiction to interpret the state statute because it's in our ordinance? All
In favor.
I think we passed the first two hurdles. The third hurdle, I believe, is timeliness.
I think you could do that. There's also the standing issue, that right, title, and interest, whether
I'm
or
sorry.
not.
Yes.
Yeah.
I see.
Either
what you're
or
saying.
is
That
fine.
was the third, that was,
Yeah.
yes, we've got four now.
Yep.
Okay, sorry about that. Right, title, and interest. The question is, and I'm going to let the lawyer speak to right, title, and interest.
Sure. So, under Maine law, there's this concept that in order, as I said, to apply, you have to have sufficient right, title, and interest in the property at issue. And so, I think the concern here is that there was some mention that in the application itself, I think it lists the property at issue as Assessor's Map U-161-1, and that Mr. Alderogi is not the owner of that property. I think the subsequent submissions show that there are other names added as applicants, but I think we want to hear. I don't believe that those folks also are either not registered, but of record as owners of that property. So, might want to have Mr. Alderogi speak to that issue.
Mr. Alderogi?
As the application indicates, I'm here to get an interpretation of a code. This has no reference to any land. That's just was provided because I was asked to provide it. So I'm looking for an interpretation of a
Right.
of a code and statute.
I understand,
And-
but the lawyers said that we can't hear this unless you are making it's got to be on a parcel of land that you own. An individual just can't come up and ask this board for an interpretation without them, it being on some parcel of land that they own.
Well, I own all that land, so I guess I'm clear there. I should be covered there, right? I own all that land there that we're speaking of.
Well, I believe we have a title of record, a tax record that shows that Mr. Moran, am I missing, that owns that piece of property? Oh, Warren's property. The current owner of 61-1 is Jared Moran.
Right, but that lot was divided, so there's a back lot on there, and that back lot was part of the land that I own.
Well, on the tax record, 61-1 is shown as owned by Jared Moore.
Right, but I'm the one who's owns the land that I'm referring to, so I'm not sure where you got that.
So in the assessor's map, do you have a lot here that you can reference that you own? 61-1 isn't owned by you, and that's the question. Do you have a lot that you can give us that you own?
Well, it's the same lots that we've discussed. Okay, hold on. So these are, do I bring these up to somebody, or?
Are you referencing the chart or the tax map that you submitted in conjunction with your application?
Yes. 1, 2, and 3.
Yes, so 61-2 is number 1, 61-1 is 2. Is that the one we're looking at?
That's correct.
Yep.
Right. And those are the 3 original lots that Mr. Pellegrino divided. And those are the 3 right there. That at the time of division, I owned these 3 lots. After he divided it and sold it to me, I owned these 3 lots that you're saying are illegal.
I guess I'm looking at, do you own 61-2?
Yes.
So basically, we can amend this your application to say that instead of 61-1,
Sure.
it's just, I understand it may be trivial to you, but I mean, we can't decide on something that you don't own.
Right.
Mr. Chairman, can we ask for clarification?
Sure.
Are you the current owner of any of these 3 lots?
I am the current owner of all 3 of these lots except for the front half of 61 and the front half of 61-1.
So further split from what we see here?
Yeah, I've been doing this for 15 years.
Okay,
And I've been doing this legally for 15 years. So yes, 61 got divided into 2 lots, and 61-1 got divided into 2 lots.
Okay, so it's further divided than what's shown on this map.
Correct.
Okay, thank you.
And Mr. Chairman, you may wish to hear from the code office about if they have any objection to an amendment to this particular application.
We don't have any objection to amending the application to refer to one of the lots that Mr. Alderagi owns.
Okay.
I do think it's a little concerning what I just heard, which is that the tax maps, there's some disagreement, it sounds like, between Mr. Alderagi and the assessor. So I don't know anything about that, so I think the town's going to have to look into that, because I think what you're referring to is the actual tax maps today.
Right.
And that's the map of record for assessing purposes, so that will have to be cleared up at some point in the future. But to the extent that there's a lot in this quote-unquote subdivision, we have no objection to moving the application forward on that basis.
Okay. Does the board have any further questions? You're comfortable with making a motion that we have jurisdiction to proceed, even though with the amended, I guess, application to reference one of the lots that Mr. Alderagi, tough name for me, that he owns?
So it's a part of a lot. It seems to be it's a part of one of these.
Can you come up one more time, Mr. Alderagi? Sure. So, if we were to pull the tax records for these lots here, your name is going to appear on one of these tax records. Is that true?
That's true.
Do we know that's true?
Actually, I was just pointing out to the attorney that if you look in the documentation I provided you guys, the copy of the building permit application, I actually have a tax card for the mother lot that he owns.
Okay, so there is a tax card here.
It is U-161-2A. So I have no objection to that because
He does have.
I literally provided all of it.
61-2?
Got it.
61-2A. What'd you say?
61-2A. I'll plug my shooters back on.
Yeah,
U-161-2A
Okay.
is the tax card that the government permits.
All right. Did I totally confuse everyone with what I just said? Are we comfortable with what we're making a motion on? Do I have a motion to, with the understanding that Mr. Elderaji does have standing here because he does own one of the lots in question?
I'll make a motion to accept that.
Is there a second? Mr. Wood seconds. All in favor? Okay. The third, or fourth, I guess now, the way I put it, hurdle we have to reach is timeliness. Would you speak to timeliness?
Sure.
please?
So, as we noted, that it's very clear in the ordinance that in order to have this board to have the authority to hear any appeal, it must be, or appeal or application, I should say, it must be timely. And under the ordinance, it talks about how it must be brought within 30 days of whatever decision or interpretation is at issue here. And so, I think it's important for us to hear evidence from Mr. Elderaji and also whatever evidence the code office has with respect to this issue of timeliness, especially and most importantly, what is the date of the interpretation that we're looking at here?
Because we have a certain time period in the ordinance to hear that.
Yeah.
Okay. Would you like to speak to that, Mr. Elderaji?
I probably have a better chance answering that if I had a denial letter. If you guys could provide me a denial letter, I could see the date on that and go from there.
One thing I think is important, Mr. Chairman, is of course that, the burden is always on the applicant to establish all elements of the application. And so, I think that the burden is on the applicant to determine timeliness. And so I'm not quite sure what the evidence is regarding the date of the interpretation you have a concern about, when that interpretation was made that you're asking this board to.
I have 30 days after the denial, correct? Well, am I allowed to have a denial letter or not?
Was it one available?
I requested it several times. I believe you have a sheet in your application, my application, that discusses how I was not getting any information from anybody I was requesting this denial letter from.
Mr. Chairman, I'm happy to address that if you'd like
Sure.
me to. Okay. So again, not having been part of this, I'm not. I think, Mr. Elderaji, what you were asking for was, I think, if I'm interpreting this correctly, Attorney Phoenix had provided a letter. I believe it was in September, right? And after that, or even maybe before it, you were asking for somebody to refute that. But I think what's at issue, and again, we want to hear from you and the code officer, is you had indicated that you disagreed with an interpretation of, the subdivision definition that was ostensibly made by the code office. So that, what we're asking for is the date of that. You have made an appeal, so obviously there must have been some kind of decision or revocation or interpretation that you are asking this board to revisit. And so that is the important date from which the clock starts ticking.
Okay, so that would be this email here. And it was dated November 8th, 2023.
I have to say I'm a bit puzzled by that because your appeal was prior to that. Your appeal or your application, I believe, was dated September 26th. So if you're asked, it's difficult to, the chronology is problematic, that if you made an application on September 26th and you're saying that the decision you're asking to be revisited is in months after that, that's a bit puzzling.
Well, according to my records, I guess I just never received a denial letter, so therefore I just went ahead and assumed the denial letter was the email telling me that the ordinance was going to be interpreted as the word preceding, meaning afterwards, and not prior to. So I only have emails. I don't have a denial letter.
And you don't need one, sir. You just mentioned that there was an interpretation you were told in an email. So what was the date of that email?
I guess I'm not sure if I can give you an exact date because this has been a conversation in an email that's been going back and forth regarding the statute interpretation. So without a denial letter, I don't have a date for you.
Mr. Shannon, you may want to hear from the code office.
That's what I was,
Yeah.
could you,
In your package, you'll see the denial letter. It's in the original, the code enforcement BOA documentation.
July
The
18th.
email dated July 18th. That starts with, "Good evening, admin. Unfortunately, I appear to have made a mistake in issuing the permit as it stands." So that was his revocation, if you continue to read that email. So the denial went out to him via email on July 18th.
If I could just add to that.
certainly.
So I think that was the last I saw looking through, or the code officer saw the last sort of denial or interpretation. Excuse me. There were obviously some series of emails back and forth, and then Mr. Alderaji did submit a letter from Attorney Phoenix on September 12th. And I think it was, and then 2 weeks later, the appeal was filed. So it was a 2-week period after, and the letter did make an argument. And so I do want to address this briefly, even though I'm not going to say it gets into the substance, but it kind of gets to I think where we are here and maybe where a solution is going forward, if that's okay. So I don't think that I think the last issue that could have been appealed from our perspective was that July 18th letter. There's also one just after that, if you want to I think there's an additional one on July 25th where Irish did respond to another sort of a response to that July 18th email where she did say that it was, she referred to the lot split in 2007. So maybe July 25th. Once the letter so that's sort of the last decision, quote unquote, that we can see other than some, back and forth. One of the issues here is, and there has not been a response. I think there was also a response at some point from Irish after the letter saying essentially the board has spoken. I think this is important to point this out because I think that's where we are, right? Which is that Irish was operating under this board, made a determination about the 2007 split. And in what you said, and I'm sure you have a copy of it, right? So in your ruling, you said that lot split violated the subdivision ordinance. You said the applicant had to go to the planning board, and then you also said even if that sort of 2007 conveyance, sort of beyond that, you made a finding or a conclusion that now beyond that, all the land is now in the same common ownership. So now it's the same tractor parcel of land again. That's your finding number 25, and so you're looking at the same lot for subdivision purposes now. So more than 2 lots in a 5-year period would require planning board review. So that was what you found. So that's what Irish is operating under. There was, and what I will concede tonight is there was additional argument made, and it doesn't appear that argument was made back or even considered back in what was the date of this 2022. If you look at the former code officer's decision that was being appealed, it simply said, there's a version of it in your packet, the original denial letter, it said there were 3 conveyances, 3 lots back in 2007, and that would be a subdivision unless any of those divisions fell within one of the exceptions. That was right in her letter. So it said unless, but there was no information that way, and I didn't see in the record where anyone made an argument one way or the other that there was an exception or not. So that was the information from the former CEO. That's the information you had. You determined there was a violation. So Irish cannot ignore from my perspective, cannot ignore your determinations. That was a determination. Now, I will say there is a new argument that has been raised. There has not been a determination from her office on that. And I agree with Mr. Eldred, there has not been. And that was partly because the appeal was filed. So you're sitting in there's an appeal. At that point, you have to let the appeal process go forward. And I also did see a letter. So I read Mr. Phoenix's letter. I had actually even spoken to him briefly and let him know that there was this decision from the Board of Appeals that was still the holding, in my view, sort of controlled that subdivision for this purposes unless the board decided otherwise or there was new information that could be presented to the board. I did see that letter in the packet tonight, which I actually hadn't seen, I'll tell you, but it looks like it was dated August 8th from James Mundy. And on the back of it, there's a letter from Attorney Whitney, who appears that he was probably the real estate attorney at the time. And he said, and from 2006, and so he said, because the Pellegrinos lived in the property for more than 5 years, they can convey 3 separate parcels without running into subdivision problem. However, it's very important, as he said, that the 2 non-house lots be conveyed and recorded first. That's because, and I'm only saying this because I want to sort of get this to the record. You don't have to make a substantive determination tonight if you can't get over the final threshold. But that's because under the statute, there is an exception, but you have to meet both parts of the exception, in my view. There's 2 parts, and I just want to read it. And this is the issue that is in the letter. It says there's an exception if the lots are created by a subdivider who, number 1, has retained, they're retaining a lot for their subdivider's own use as a single-family residence. That's the first element. And that residence had been their residence, their principal residence, for at least 5 years preceding that division. So in other words, you have to have had it for at least 5 years as your principal residence before you divided it out. And you have to retain it for their own use as a single-family residence. Now, that has never been fully defined. How long does it mean to be retained? How long do I have to keep it? It does not say anything in the statute. There are other exceptions that do explicitly say. For example, there's a gift provision that says you have to keep it for 5 years before you can divide it out. It doesn't say that in this one. It just says you have to retain it. So many real estate lawyers do take the position that's consistent with what I see with Mr. Whitney saying and consistent with what I've seen Mr. Phoenix say, which is retained literally means it could be for a second longer, meaning you have to record it last in place. And so that's why I believe it says this in this letter. He says it's very important you record the house lot last.
That's why he said it, because you have to retain it as your single-family residence. Now, whether that's the intention of the legislature or not, I don't know, but it is, in my view, a somewhat reasonable interpretation of that provision. And so, to the extent that there is no appeal here tonight, because maybe there's not a 30-day provision, I think what we are willing to say is the code officer is willing to look at a new application, given that new information. But we really did, and I felt like I wanted to explain this. It really felt like her hands were tied a bit because of the very clear holding you guys made last time, is that there was a subdivision violation with the 3 lots in 2007. So I'll just put that out there. I don't know if that's something that, I'll just say that. The code officer is willing to take a look at that with this new information. We had she had the 2 things happening, which was there was an appeal filed, and there was also your previous determination that was sort of holding that back. And I'll rest on that.
Thank you. So, Mr. Algeragi, the letter that we have is July 18th or potentially July 25th. Would you like to speak on that?
Well, the letter I gave you with my application is dated September 12th. The letter I gave you. Now, that's the letter that was requested for me to provide by a lawyer that specialized in real estate, and so I complied with that request from the code enforcement officer.
The appeal that we have here is dated 9/26, though, and I'm not sure that this board has the authority.
Well, this is 9/12, so that's less than 2 weeks.
But we're all of August. I mean, July, August, September.
No, this
We have a
September
30-day time period in our...
September 12th is this letter is dated September 12th.
But the denial was in July.
No, because if I'm being asked to provide a letter for clarification to find all the fact-finding, and this letter was given by the lawyer on September 12th, and she looks and reads the letter, decides that either A, agrees or disagrees, and at that point, I would assume that's when the clock should start.
I guess I'm going to ask for a little clarification from the lawyer. The 30 days is really kind of got me stumped.
Sure, it is. It can get confusing. So I think you've heard from the code office that the interpretation, their perspective is that the interpretation runs from either July 18th or being generous, July 25th. Have I got that right? And I heard Mr. Algeragi say that it would run from the Tim Phoenix, is it Tim? I'm sorry. Tim Phoenix letter of September 12th. But I think it's important that the interpretation at issue, at least the way I interpret the ordinance, is with respect to the code enforcement officer's interpretation, not an attorney that he's retained. I think, just extrapolating a little bit, if there was a follow-up from the code officer on that Mr. Phoenix or Attorney Phoenix's letter, I don't know what the evidence is in that regard. If there was a determination on that, as Attorney Saucier said, additional information provided, that additional argument with respect to the information that had not been considered previously, I just don't know if the record indicates that the code office responded to Attorney Phoenix's letter on that issue, on that additional issue.
Right. Are you saying, just to make sure I understand what you're saying, were there any kind of interpretations that the code officer issued after September 12th?
Correct.
I don't believe so. There were some emails about asking her to provide it, or asking the town attorney to provide an interpretation, but there was never any interpretation. just from a, and again, I sort of think they're sort of, I do think the town is looking to move this forward. I want to say that for the record. The town wants to work, I was given the direction, the town wants to work Mr. Alderaji to move this forward. Wants to be productive. So two suggestions I have are, to the extent that you find that it was untimely, and appears to be untimely from my perspective, that you could either, and I actually don't think you have the jurisdiction, this one thing you could do is remand it for an interpretation, or I think what I've said tonight, with permission of the code officer, is that the code officer would be willing to entertain a new building permit application. The one, it was previously back in July, with this information. The only thing that again, to Attorney Rachel, I don't know how to do this, but it's a concern that the board's final determination, to me, was that it's a violation. So it's sort of with the tacit understanding.
Meaning the previous decision.
The previous
Yeah.
Position about the 2007. That's kind of that's in the file, right? So you can't ignore it. That's in the file that was a violation. So the only thing I would say is, to the extent that the board is willing to say, to the extent there are new facts and new information, that's a new scenario. And that would, I think, give the code officer the authority, or at least the comfort, that she could take a fresh look at the 2007 conveyances, given the information that Mr. Alderaji has provided, and not run afoul of your previous decision. I don't know if that makes sense, but that's kind of what we need from the board, and then the code officer is willing to take a look at that with that information, and I think there's a reasonable argument in there.
That certainly makes sense to me. The question I have is, if we go ahead and do that, does this board need to do something with the fact of finding a fact that we have? Do we need to look at that information?
So this is a very novel situation, I will say. So we're kind of thinking out of the box, so to speak. But were you to determine that this this application was untimely, you could make that determination, and also, as Attorney Saucier had indicated, make a finding that we determined that there is additional information that has been presented that makes this a different animal, so to speak, from our prior decision. Arguably, if it's untimely, you might not need to make that, but in order to be practical and fair to the applicant, and everybody here in this room seems to want to get to,
right,
unclog the drain, so to
Right.
speak, I think that makes perfect sense from a practical standpoint, and I don't think there's anything illegal about that.
No.
So,
I think it makes sense, and from the town's perspective, I think probably from the applicant's perspective, it makes more sense to cut to the chase, right? Which is that we want an answer on the building permit that was submitted, and not have appeals based on
Right, and just go on. That's what I'm concerned with.
Right.
So we find this untimely, but we're willing
We
to
still don't
work,
get to
but
an
you
answer.
still don't
Right.
have the jurisdiction to do that, so we're back here again,
Yes.
hearing the case again.
So that kind of finding that you suggested, that you heard testimony that there's additional information, and that I think it doesn't hurt to even say,
and we so find.
and that the code
Yeah.
you so find, and the code officer will review the building application with that new information.
Can I ask for some clarification, if it's
Yes,
okay,
please.
Mr. Chairman? What I'm assuming, and you know what they say about assuming, but the building application would not be with respect to the map and lot indicated on the application, but on the map and lot for the property that Mr. Alderaji actually owns, and which may have been the subject of this.
That's right.
Okay.
I understand there was the correct.
Yes.
Yeah, there
Yes.
was. the
He
building
originally
permit.
applied with the correct map and lot for the building permit. This application's different.
And I
s-
don't want to prejudge anything.
Of course.
Look at the application. There may be other issues. There may not be other issues. But as it relates to this 2007, I think we're willing to kind of move beyond that at this point and look at the application with the information that's been provided.
So, just for Mr. Alderaji's benefit, and so everybody here understands what I think is possibly a resolution here.
Okay,
And I'm speaking hypothetically because
we haven't made
you
it.
are the board and you
Right.
make your decision. But in the event that this board determined that the request before you right now is untimely based on the chronology that we've heard from the code office, that, there would also be a finding that based on additional information presented, this makes this a different situation from the past, the past findings, in fact, and conclusions, which essentially would not hamstring the code enforcement officer from taking a fresh look at a new building permit application.
And this would only be on the findings that we had back originally on the initial subdivision.
And
Yes, and-
2007, yeah.
Yes, and just to be clear, and Phil had mentioned this before, but I want to make sure this is a lot of legalese, so I want to make sure everybody understands this, is that I think it's quite right that because the code enforcement officer was facing a determination that this was an illegal subdivision, that her hands were tied, and she's not going to essentially end run the ZBA's decision. Right? However, as I think is implicit in what we're talking about, is that ZBAs are not a precedent-setting board, so you are not bound by a prior decision because you're being or could be presented with new and additional information. And in that event, that you're looking at it afresh. So,
Okay.
Is that a fair?
That's fair to me.
Yeah.
Mr. Algiardi, are you okay with what's been discussed?
Yes, that does sound promising. I just wanted to, go back in regards to the timely thing, because I didn't get a chance to finish talking about that, or maybe moot at this point, but, there was discussion after the letter was written, and there was email back and forth between Mrs. Griffith and Mr. Phoenix. The email's right here if anybody wants to see it, but it seems like that may be moot now. So back to the building permit. I did receive a building permit already from Mrs. Griffith, so I would just like it reinstated if that's possible. It was rescinded the day I received it.
It would not be able to be reinstated. You only have 30 days from the time that it's.
And that wouldn't be within this board's purview to.
I don't have to pay another $3,600 though, right?
I'm going to charge you $5 million. No, no. And then you know better.
Okay.
I told you we'd work that out.
Okay.
So I'm going to kind of look at the board right now, and we've had some discussion back and forth here. Does the board have any other questions about where we seem to be headed at this point in time?
No, I wanted to clarify that this only has to do with the 2007 facts
Decision.
of finding of facts that we found. It has nothing to do with the rest of it, the property as it exists now and
Right.
that kind of thing. It has nothing.
Right, we've
not-
only been presented information on the split, the original split,
Yeah.
and that's what the
Yeah.
findings are going to indicate. Yes, I think that is accurate.
But what is standard reason if you're finding the 2007 Pellegrino split to be legal when that just fix everything else that happened after? Because before you were saying everything else that happened after was illegal. So now that you're finding that what he did is legal, everything else after should be legal.
We didn't hear anything basically on that. Our finding was on the original piece. That's what our finding was on. So whatever's happened after that, you're going to have to work with the town in determining what the status of your property is right now. What we're talking about is only the original split, and that's what we found in our findings. That's when we basically couldn't move forward from that, because after that we couldn't fix what had already been done. We've heard evidence now that says that split appears to be is accurate. It was done properly. That's what the findings of this board will say, is that split was. We found that split to be okay. Now the code officer can look at the permit and not be tied to the decision we made on our last finding.
Okay, fantastic. And I think you have something under 14 in regards to your rules that says that Any land use ordinance may be changed or amended by a majority vote of board members present at a regular meeting after the proposed changes have been read at one previous regular meeting. So I don't know if that pertains to this. I just wanted to, that's number 14 on your
Okay.
list. Thank you.
I'm going to ask you what we need to do, because
Sure.
I'm not entirely sure now.
Sure, I know, this is uncharted territory. So I think what I would suggest is, if memory serves, we were talking about the timeliness
Right.
prong, and I don't think I heard a motion, made or seconded or discussed, that you may want to make a determination on the timeliness issue, and once you do so, you could also address, and I think that, I haven't heard you direct me to draft findings, but can I assume that that is
Yes,
something
you
the board would
can.
like me to do? In which case, you may want to direct there to be a specific finding and conclusion regarding that, the code enforcement officer should not be bound by the previous decision because there is new information, an argument that has come to light, which makes it a different animal, essentially.
I like that, because I don't want to set precedents on the timeliness. I mean, the ordinance says we have 30 days, and if it's past that, we would have no jurisdiction. And so, but based on what we've talked about, we are also going to have a finding after that, and I'm comfortable with that. Is that something that the board would be comfortable with?
Yeah.
Okay. So I guess I'm looking for a motion that we don't have standing to hear this appeal because the timeliness was not, the 30-day time limit was not met. Is that accurate? Do we have a second motion on that? So moved. Mr. Woods has moved the motion. Is there a second?
I'll second.
So we have a motion and a second. So all in favor of denying basically the application because of time, because it didn't meet the 30-day time limit? All in favor? Okay. So now, we've opened the hearing, now where do we go? Because we still have a hearing that's open, but we guess we need to find the finding of
Yes.
fact now?
You do, and I think based on the conversation that I've heard, that I can provide findings and conclusions for your consideration and adoption at your next meeting. Now, I will say, and of course I don't have it in front of me, but I believe that there's a requirement that there be a vote, a final vote, and I think what I would suggest is that I've heard what your direction is, and that I draft up appropriate findings, and that we can reconvene, and you can review, exercise your independent judgment, make sure that they're consistent with what we've talked about today, and that you can do a final vote to adopt them then.
So basically, we'll close the hearing,
Mm-hmm.
and we still have 45 days to reach a decision or something like
Yeah.
that. But we have time to
Yes,
reach a
I mean,
decision.
I think what makes sense is actually that we get a date certain to get back here.
Certainly.
And I don't think it's necessary, and I'm happy to come. I won't be offended if I'm not invited to the party, but I'll provide you with draft findings that you can review. And of course, don't just adopt them. Make sure you review them, make sure that they are consistent with what
we
you're...
want.
Yeah.
Yep. Okay, so then we will close the hearing. And then let's set a date that we can meet. I guess I want to give you, how much time will you need?
I can get these done in a couple weeks,
Okay.
if that works. I just don't... When's your next regular meeting?
Well, typically we meet the second Wednesday of every month. So that would be what?
December 13th.
December 13th.
I will-
Would that
You
be
bet.
acceptable to everybody? Okay. So I think that we'll set the next meeting for our regularly scheduled meeting.
17:30.
Uh, What's that?
1800 at the time.
Yeah, what time we want to meet? 5:36? What's convenient for this board?
7:30, 5:30. Yep.
5:30? 5:30, okay? So we'll set a meeting for a regularly scheduled meeting on the second Wednesday to review the finding of facts that we've discussed here at this meeting, and,
That will include an unbounding
right,
from our last.
Yep.
Which is,
good enough. Does that get, we've got a couple more orders of business, we have to approve some minutes and stuff, but I think that pretty much ends this portion of the agenda.
I'm not good going.
Thanks, Matt.
Very good.
Thanks for everything. I'll let you know about that.
Okay.
May I steal some of this stuff? I just want to make sure I got all three. This is this. I think they have some duplication here.
I
right?
mixed some stuff up.
Okay.
I think, too, yeah.
No, I'm going to ask Terry. Just,
Okay, yeah.
Right. Thank you for
Yes,
sharing.
no
I
problem.
appreciate it.
Well, that's all right, we'll do it at the end. So, let's
Hello.
let everyone kind of clear out for a few minutes, and then we'll, the only thing we have left on the agenda is to approve the minutes, which shouldn't take long. So we'll let everyone kind of clear.
do we all have a copy of the minute?
They're right there. They were pretty brief. Okay, could we ask,
Where are the minutes?
all right, could I ask if you could go outside, so that we can complete our meeting, sir? Could you just step outside so we can complete the meeting? That's okay.
Good night.
Light at the end of the tunnel, ladies.
Okay, Pat, did you get a copy of those minutes?
They're in this book somewhere.
I don't know, I was looking, if, I may not,
There's a copy there.
I may not have,
Pretty much, we just opened the meeting just so that we could approve the minutes of the meeting before.
this is it?
Yeah, that's it.
All right.
Are we okay with the minutes as written?
Oh, yeah.
All right, do we have a motion to accept the minutes of, what was that?
So moved.
September 13th.
September 13th. We've got a motion, we have a second.
I'll second.
All
Who
in
made the
favor?
motion, I'm sorry?
Ernie and Jacob.
Sorry. Now, I think the last thing I need is a motion to adjourn. Do we have a motion to
That's
adjourn?
it easy.
I'd like to make a motion to adjourn from tonight's
Mr.
meeting.
Cotton adjourns to the first motion, second motion?
I agree.
Pat agrees? All in favor?
Aye.
All right. Thank you very much. We got through it.